Why do banks deny durable power attorney documents in Florida? Kellen Bryant, board certified elder law attorney. And this is one of the biggest headaches that we have to deal with, both from a messenger standpoint, but also dealing with powers of attorney, because what banks do is they will take the power of attorney brought to them. The customer service rep that you're talking to, they don't know anything. They actually send it to their legal department. The legal department oftentimes are not Florida attorneys, and you're not allowed to talk to them. And so when they review your power of attorney, they usually do not know that Florida law has changed as of October 1st, 2011, where they'll either not know the law or they will know it and they'll use it to the extreme, or your attorney doesn't know it, or your online form doesn't know it. So what happens is when the banks deny a durable power of attorney, it's because there's very, very specific wording that is not said in that durable power of attorney document that you have. So for certain banks, they're looking for very specific language, very descriptive, granular, detailed language, and they're looking for a specific statute cited. That is one of the main reasons why banks deny durable power attorneys. Also, banks will not like how the name on the durable power attorney may not match the name on the account, and because that account oftentimes was created long before a name change that occurred from a divorce or whatever. And formerly, you used to be able to just say what your name is without any kind of formal identification that's required. And so they'll deny powers of attorney on that basis. Now, in the case of a lot of do-it-yourself forms, a lot of people just don't sign the power of attorney correctly. Sometimes people miss witnesses. Sometimes the notary forgets to put their stamp on the durable power of attorney. And oftentimes they'll make up own rules, like they'll say the durable power attorney is too old. That's false. That is not a reason to deny a power attorney. Or they may say, we'll accept it, but you need to provide medical evidence. And then a lot of times we'll see people get all angry about it and go Karen mode with the bank, and they'll say, here it is. And the banks will interpret that as and they'll think you're an exploiter when you act like that. And so, the banks will use that medical evidence and say, well, this person does not have capacity right now, and they'll make legal judgments. So a lot of times banks don't know how to handle this, and that's why it's good to have a good power of attorney done on the get-go and only provide the things to the bank that is legally required, such as an affidavit saying that you still have the power, some IDs, and the document, and nothing else. If you have any questions, comment below.